Yes, thank you, Sen. No practice direction yet, but that's coming, is it?
I think it is.
Sorry?
I think it is. I think it's been identified over lunch, and my learned friend is going to deal with that.
Good. Okay. Dealt with later. That's fine.
I'm starting with the Rule 43 point, which is why I hope, my lords, my lady, you have in front of you a small clip just with the provisions of the statute, so we don't have to go back to Pleskin.
That's very helpful. Thank you.
So just the headline point is that the exclusion applies to reviews, not set-asides, and the rule I rely on is a rule about set-aside, not review. So Section 10 provides that in 10.1 provides that the Upper Tribunal may review a decision made in a matter other than a decision that's an excluded decision. And we looked behind so Section 13 is where we find the definition of an excluded decision. Which is behind, you've got 11 for posterity, frankly, and then 13. And the provisions as to what is an excluded decision are in Section 8. Paragraph 8, and it's an appeal at C, which refers back to Section 11. Any decision on the up. So it's, I think, uncontroversial that a decision to refuse permission to appeal is an excluded decision, and that is not reviewable. And that was the point made by Baroness Hale in Cart. And for your note, that was at tab 4, page 70, paragraph 28. Yes. But the rule on which I rely is a rule about set-aside, and the Upper Tribunal rules deal with review and set-aside differently.
Hang on 1 second. Sorry. Yes.
So behind tab 3 of the authorities bundle, you have a complete set of the Upper Tribunal rules. And at page 8, you see the index to part 7.
Page 8, yes. Yep.
Yes. And then you see setting aside, Rule 43, the rule on which I rely.
Yes.
And then below that, 46, review of a decision.
Yep.
And then at page 38 of that bundle, you have Rule 43. Which provides that the Upper Tribunal may set aside a decision which disposes of proceedings and remake the decision if the Upper Tribunal considers it is in the interest of justice, and 2, one of the conditions, and 2 is satisfied. Now, the conditions are fairly specific, A, B, and C, essentially with documentation not being provided or someone not being present. But then 4 says there has been some other procedural irregularity in the proceedings. And pausing here, this does seem quite apt to deal with what's happened in this case. 46 is over the page on page 40, which is.
Sorry, I just want to have a look at the specific. So, yes, I see. So none of A and C apply, but you say D might.
Yes. Yeah. And I suppose the other point to make before leaving this rule is that it simply doesn't refer to excluded decisions.
It refers to a decision which disposes of proceedings.
Yes,
and is that a defined term?
It's not, and that's what Pleskin decided.
Yes, I see.
So Pleskin held, and this was the paragraph 15 we
Sorry, no, you're about to take us to
46.
46.
which simply provides for a statutory power to review.
Hang on. So I don't quite understand how all this fits together. Is there a power of review as such, or is that
Yes.
is this assuming there's the power of review in section 11 or section
10?
in
Yes,
the statute?
that's the statutory power, and this
These are glosses on that. Is that right?
Exactly.
Would you mind going back and just taking us through? I mean, this is part 7.
Yes.
So at 37, we start with that,
Yes.
and 41 distinguishes an appeal from a review.
Yes.
42.
I see. This review mean. I didn't see it. Review means a review under section 10, right? Yeah.
Right, I'm asking for your help with this, just to take
Yes.
us through. So 42 is a slip rule.
Slip rule.
43 you've shown us, but then we get to application for permission to appeal. So how does it all fit together?
So, if there's an error, this sets out the number of ways in which you can deal with it. There's, in certain circumstances, you can review. In certain circumstances, you can set aside, and in certain circumstances, you can appeal. And my submission is that here, it was available to the appellant to apply under Rule 43, to have the decision of Upper Tribunal Judge Grubb set aside and remade, taking into account the supplemental ground of appeal. And the relevance is...
Wait, sorry. 46. The Upper Tribunal may only undertake a review of a decision pursuant to 45. So what? The whole of the rest of section 10 is excluded?
Yes, I mean, I think that is a limiting power onto when it's... So there's a statutory power to undertake a review in section 10, save for the fact there's a statutory limitation on excluded decisions. And then you have...
Hang on, sorry, you're taking this much too fast.
My apologies.
Yes, I'm not got to 46 yet.
Okay.
45 is defeating me just at the moment. What's that all about?
Is it helpful if I go through... So we've got 44. We've, I think, covered that.
Well, 44 is all the rules about ordinary application for permission to appeal.
Yes.
So we know about that. We don't need to know about that.
And 45 is Upper Tribunal's consideration of an application for permission to appeal. On receiving the application to appeal, it may review rather than undertake the application for appeal in limited circumstances.
Sorry, what does may review the decision mean?
So 45.1, on receiving an application for permission to appeal, the Upper Tribunal may review the decision in accordance with Rule 46.
So review means may undertake a review of the kind provided for in section 10 of the Act.
Yes. But as limited by 46.
Okay, well, let's stay at 46 in a minute, but may only do so if the Upper Tribunal...
Overlooked a legislative provision.
Yeah, or there's been a change in the law.
Yes.
Or a change in the case law. And if it doesn't review, then it must go on to decide PTA.
So review is, excuse me for talking about that, review is it's a sort of streamlined appeal situation where there's been an obvious problem because of some change in the meantime, or something's been overlooked.
Yes, and my submission is that that's not this case. That we are in Rule 43 territory, the set aside case.
Okay, but we just need to, in order to understand that, we just need to understand. So what happens when you review it? What's the outcome?
I mean, I think...
Review in ordinary English just means look at it again. But does it mean change?
Yes.
Yes,
So
I
that's a
see.
46 too.
Okay. So someone puts it. The way it works is someone puts in an application for PTA,
Yes.
and you think, hang on, we don't need to have the whole mechanism of an appeal here. Something obviously gone wrong of this change in the law nature. We'll just change it
Yes.
back to what it would have been if. Is that right?
That's right, but that's perhaps why it's quite a limited power, in that it only is engaged in certain circumstances. You don't always get to redo, and sometimes the only route for correction.
Well,
is
hang on, but
an appeal.
overlooked a legislative provisional binding authority could have had a material effect on the decision. So does it do all this on paper? Does it not tell the parties and say?
I think it probably has a discretion to issue directions. It probably depends on the nature of the error. If it was a new case, in my experience, that one would be asked to provide submissions on the new case.
It might be that's covered by 46.3. So the effect of 46 is that's the only kind of review there. The only kind of review there can be. Section 10 being in very broad terms, this cuts it right down. It says the only way in which you can review is in the context of an application for PTA. And then here are the conditions in which you can do it, and here are some provisions about it. Okay, I think I'm there. So you say all very interesting, but this isn't about review. This is about 43,
Yes,
which is described as what? Set aside.
set aside. And it provides a power to set aside and remake.
And a decision which disposes of proceedings could include an excluded decision for this purpose, because this isn't a power to review, it's a power to set aside.
Yes, and that was the point in Pleskin.
The point in Pleskin.
Well, the point in Pleston wasn't about excluded decisions. They didn't even look at those because they weren't relevant.
I think there might have been some discussion of it, but yes.
Was there?
I don't think it was particularly determinative, but
I mean, it's true that 13.8 is set out. But
yeah.
So the power of the Upper Tribunal to review and then separately well, in fact, yes, no, I think it is referred to by Lord Justice Lewis at 10. A decision refusing PTA is an excluded decision, and therefore, so he effectively, without referring to Cart, he says the same thing as Lady Hale in Cart.
Yeah.
But then he says set aside is different. He doesn't.
I think the point is at 19. Mr. Tommen was advocate to the court, and he makes the argument that one of the issues he'd engaged with was the principle of the exclusion in section 13. And then that was
Yes.
rejected.
Yeah, okay. Thank you.
So, my submission is that a fundamental procedural error, such as cannot arise where the applicant, the appellant, had an available avenue to ask the Upper Tribunal to set aside a decision and elected not to exercise it. Now, my learned friend says that Pleskin postdates the appeal in this case, and of course that's correct. But the provisions on which I'm relying are clear from the rules, that they simply they are different from the power of a review, and that Pleskin didn't change that.
Yeah.
They have fleshed out what meant by what disposes of the proceedings, but it was always open to make an application under Rule 43.
Yeah, so Pleskin isn't new law, it's just simply explaining how the rules fit together, effectively.
And here, I think I'm repeating myself if I say that this it seems to be that a particularly efficient way of dealing with the issue that arose here. And that goes to my learned friend's policy point, which I say, well, there can't really be anything in it, because if the rule is there, the rule is there. It's not, we can't ignore it. But to the extent one says that's inefficient, well, that it is a much more efficient process for the Upper Tribunal to simply revisit its decision on permission to appeal than to apply for a judicial review under Section 11A.
And quite, I mean, you're deploying all this about under the heading of 11A 4C2, but in fact, it's would be a completely different reason for not giving judicial review, namely the availability of an alternative remedy. Is there a time limit for an application under Rule 53?
There is 43.4 in this type of case, in an asylum and immigration case, it must be received within 14.
And that's presumably extendable, like all is extendable in
But
principle.
it would flow from the Upper Tribunal's notice. So here, once the decision of Upper Tribunal judge they would have had, I think, one is in the UK 12 days after the Upper Tribunal decision.
Yes, but I'm just thinking about how it fits into a judicial review analysis. If you were judicially reviewing it, you would be able to say, if you were the defendant, suppose there was no, we weren't troubled on the jurisdiction point, you would say judicial review should not be granted because there's an alternative remedy. You might then say, well, I'm out of time for the alternative remedy. And in practice, it would be a then discretionary matter for the judicial review to say whether it was a sufficient answer to say, well, that's your fault. Or to say, well, you can still go and apply. Well, the answers to that point would be, one, that's your fault if you're out of time. The other would be, you're not definitively out of time because you can always apply for an extension. Yeah.
How was this argued in front of the judge?
Well, the point was raised in Secretary of State's AOS and summary grounds, but it really went to the jurisdictional. It was raised in the context of the jurisdictional point rather than.
But this argument didn't find its way into the judge's reasoning. Is that right?
It was. That's right.
Right. So it was there for him to alight on if he'd wished, but he didn't alight on it.
Yes.
But he didn't really need to, because he chose to take the shortcut of saying, well, I'm still not quite clear whether he did say I'm not sure this point's good, but it's disputable, or whether he said, I'm not even going to decide whether it's disputable because it's just there's no substantive. We'll come to that in a minute, no doubt.
Yes.
But either way, he was either deciding or assuming that there was an arguable point, in which case he didn't need to bother with why it was arguable or going into all the details.
And for the purposes of the alternative remedy argument, I mean, the only question is whether the alternative remedy is a suitable alternative remedy, and the existence of a time limit wouldn't make it unsuitable.
I think that's right, especially given the ability to apply out of time.
Yeah.
You had a good reason.
But can you just remind us where the power to extend time is, please?
I think it's the general case management power in 5, which is at page 13 of the authorities bundle, and it's 3.1. 3A, my apologies, extend or shorten time.
Sorry,
So
5.3a.
5.3A.
Yep. Okay.
So that brings me to my third reason why what happened here was not a fundamental breach, and that looks to the nature of the supplemental grounds of appeal, and that they didn't differ significantly from the original grounds. may well have been that my learned friend drafted them better and set out the Mobeen case specifically, but the arguments had already been raised and engaged with around the proportionality analysis. I mean, that's what's being challenged. And
well, can we just be clear about that? You'll show us the detail in a minute.
yes,
But I understood the reason why Mr. Mallet said it is a new substantive point, and frankly a better point, he says, is that it hooks on the fact that the judge found that family life was not engaged. Now, is that point in Mr. Saini's first two rounds? I don't think it is.
It isn't.
So it is a different point.
Yes, but
And quite an important different point, isn't it?
well, I do disagree there because of essentially the same reasoning deployed by Mr. Justice Griffiths, and this is really the second bit of my submissions, which is that it is a labeling exercise here, given that it's quite clear the first tier tribunal took into account all the relevant factors which weighed in favor of the appellant.
Yes, I see.
And that's why I say that the proportionality analysis is what it is, and it doesn't. Nothing in some cases, family life is going to be evaluated differently, but in this case, there is nothing in particular about the facts of this case that would have been evaluated differently had the judge approached it, calling it family life rather than a strong private life. That he's ticked off all the relevant characteristics, and to the extent that we're dealing with a question of weight, my learned friend hasn't established that a significant amount of weight, or that there was an error in the weighing process. So that's...
Well, the point that he's making is not to do with identifying the factors, but to do with that he may have had in his mind that there was a little weight principle. I mean, that's the argument
Yes.
that I think you're...
I'll come on to that if I may.
Okay.
I may do it when I'll just quickly finish up the...
Because this point really comes in at two stages, doesn't it?
Yes.
You're just deploying it here under the heading of no fundamental justice, which is a sort of big picture point.
It is.
Okay.
And it goes, yes.
Thank you.
So just the last point is just this bit about wasif and the duty to give reasons. I mean, frankly, I take my lord's point, and that this is a red herring, and I frankly have a harder task in front of me than to persuade you that a duty of reasons was satisfied, because it couldn't have been satisfied because the grounds weren't before the upper tribunal judge.
Yeah.
So I've dealt with, to the extent I've dealt with it in my skeleton argument at paragraph 32. If I could just ask the court to take a look at that when considering this point, merely for the point that to the extent my learned friend says that there is an elevated duty to give reasons because of Section 11A, I say that can't be right, given the fact that court appeals we've always known that this could be the end of a road, a refusal of permission. But I've set that out in more detail at paragraph 32, and I do not need to say anything else about it here. So turning then to the decision of Mr. Justice Griffiths, if we could turn that up at paragraph, it's page 72 of the core bundle. And this is really the key reasoning. The first point I need to deal with is whether or not the judge applied the correct test of arguability.
Yes.
And I think I can take that quite quickly. So if we look at 26, this is the impugned statement, arguability plus an important point of principle.
Yes.
But if you go through the rest of the decision, It's quite clear that the issue that the judge was addressing was arguability.
Okay, so let's just, implicit in that, but I just want you to spell this out because I thought you were arguing something different in your skeleton. Implicit in that is you accept that the test is pure arguability.
Once you get beyond.
Once jurisdiction is established, it's pure arguability. It's not hard.
No. And so we see at 27 a decision on the facts of this case, and proportionality assessment was 27 and 28 are the judge recanting all those factors that were engaged in the first tier tribunal's analysis. And then at 29, ultimately the judge found that the absence of, this was essentially the labeling argument, which I've referred to it, but at 30, I do not consider it arguable that the judge's decision fell in favor of refusing the appeal was wrong. And then the proposed appeal at the bottom is not arguable on any basis. And then at 32, the reasoning was not arguably wrong and wrong. So that's the short point there.
No, I understand that. But just if we're giving guidance for the future, it's just important to accept it's common ground that it's pure arguability. The judge then does slip into error, but you say not material error, by using the language, even in this slightly garbled form, at least as transcribed, of important point of principle or practice. That doesn't come into it. Yeah.
I'm grateful for that.
Can I just be quite sure that you accept Mr. Malik's analysis of how this works? If 11.4 is engaged, 11.4 applies, therefore 11.2 is disapplied, therefore it is the Upper Tribunal's refusal of PTA is reviewable on ordinary principles.
Yes.
Those principles, it is the case, is it? You agree they're not spelt out in any rule like they are in the High Court. They are just a matter of practice. That is to say, arguability.
Yes, for the Upper Tribunal's
Yeah.
decision.
So any idea why? It's just slightly surprising.
I don't know. I think there was some work done over lunch to find the. I have to confess, I was printing something else, and so I haven't had a chance to go through some guidance.
No, everyone's done a lot of work on this, but the back of my mind, 54.7a, which is the cart rule when it was there, did, perhaps because it was a special rule, enshrine it in the rules, didn't it? I think that's what 54.7a did.
That's right, and then it was.
Had it been removed at the time of this? Wasn't there a delay?
It had been.
Yeah.
Because I, around the same time, in LA, got myself into a muddle before this court in terms of which rules applied with regarding permission. So I do have a vague memory of the fact that the rule change had occurred, at least by the time of the permission hearing in this case, which was around the same time as then. I will have to double check exactly when it was removed, but memory is that it was July-ish.
Well, you just have to think yourselves into what it'd be like for us writing a judgment or judgments on this. We're going to want to set out how it works. Yes. At the moment, as far as it's a matter for me, I will be saying that the structure of it is that 11.2, when 11.2 is disapplied, you simply go back to what the to the arguability test, which is established as a matter of practice in the Upper Tribunal.
Yes, although I suppose the arguability test in the High Court, which then applies, which is looking to
just I suppose.
What the Upper
Okay, I'm ignoring.
Yes,
I say arguability. I imagine. I don't know. I haven't seen this practice direction. I imagine it tracks the High Court, in which case it is either arguability, which is normally the test, or exceptionally it might be some other compelling reason.
I wonder if the right thing for us to do is just to maybe see if we can put together something in jointly and provide it to this.
I think that would be helpful. Perhaps if you don't mind, can I just ask Mr. Malik what the
Yes.
result of his researches has been over lunch?
Yes, can I just hand off the document then? It's not, I'm afraid, Learned Friend has seen this
Yes.
document. I'm afraid it's not a practice direction. It is a presidential guidance note that deals with this issue.
To be fair, I think that's what you said. As I said, you said it, but I asked you whether it meant it was a practice direction in the full sense, and you said no. So I think we weren't seriously misled. Yes, thank you.
I mean, this is a lengthy document, but the paragraphs that will assist you. If you go to page 9 of this,
Can we just have the date of this? August 2019. And it's from both presidents.
yes, go to page 9. I mean, it deals with a number of different topics. At page 9, just above paragraph 35, you'll see heading, what constitutes an error of law. There's a reference to R on, and you then look at the last sentence in that paragraph. It must always be recalled that in dealing with applications for PTA, judges are concerned only with whether there is an arguable error of law, not whether the error is made out.
Well, then it goes back to paragraph 4.
Yes.
Can we just see what it says in paragraph 4?
Last sentence of paragraph 4. You'll see that word arguably is
It involves.
okay. So that's that. And then if you
Yes, but
if you,
in a sense it's obvious,
yes,
but on the other hand, you'd expect it to be more than just a single sentence of guidance. You'd expect it to appear somewhere.
if you go to page 11,
Yes.
you'll see what is said is that the existence of a reasonable prospect of success is relevant, but it's not precondition. So there is no precondition as such in the legislation.
Yes, I see. So this is effectively not using quite the same language. This is some other compelling reason.
Yes, real prospect of success or some other compelling reason.
And I see it does actually refer to some case law then. It goes back to a case called Anno Liefo.
Yes.
Okay. Well, I don't want to. That's helpful. But everyone is agreed that there is no test in the statute or the rules saying what the test for permission is.
Yes.
Okay. Thank you very much.
So, turning then to the factual analysis, the substance of what the first tier of the Mr. Justice Griffiths analysis of the Upper Tribunal and the first tier tribunal. The judge proceeded to consider the first tier tribunal decision in some detail and correctly concluded, in my submission, that it contained no arguable error of law which could lead to an appeal. And by way of reminder, the first tier and as my learned friend has already outlined, the first tier tribunal judge considered the issue of cohabitation, so the fact that the appellant resided with her uncle, the issue of support, so the support the appellant provided to her uncle. That support was mostly in the form of providing care to her uncle, and that was the primary way in which that relationship was evident to the first tier tribunal judge. The first tier tribunal judge made a very clear finding on the nature of the bond between the appellant and her uncle, which was close and included an element of dependency. And that all fed into the conclusion that aspect of that life between them was worthy of respect. And we've already looked at the heavy consideration given to the judge of the impact of the appeal of the decision on her uncle, who was a British citizen. The judge also found in reference to my lady's observation and this is the decision which begins on page 172, there was focus on the rights of the appellant and the impact of the decision on her. The Article 8 analysis started, and I'm on page 179 at paragraph 29, with the finding that there were no significant obstacles to her integration in Bangladesh. So the Article 8 analysis within the rules, and then it moved on to the analysis outside the rules. So there had already been a significant consideration of the impact on the appellant, and the judge went on to consider.
But no insurmountable obstacles doesn't really deal with the relationship aspect of the impact on the appellant. It deals rather with what would happen to her if she were returned.
Yes. But it does deal with the ties. It does deal with the ties between the appellant and her uncle. So at paragraph 30, she provides daily care for her uncle and supports him emotionally. So the ties between them transcend the usual bonds that exist between adult relatives. And over 34. Again, they have a close bond and a close private life. Implicit in that is if she is to be removed, that would be disrupted. The analysis, well, that specific step isn't taken. It's plainly there.
A strong private life that is worthy of respect is
Yes.
a mutual
Yes.
state of affairs,
Yes.
not just looking at it from one or the other, but both.
Indeed, logically, no, forget it. Well, the point I was going to make was she does focus on the claimant's private life, because by definition, analysing it as private life means her focus is on the claimant. So that box is already ticked. It's true that calling it private life and not family life means that she doesn't logically then have to look at the effect on Dr. Alam. But your point is whatever label is used, she does, and puts that very much into the balance.
Yes. And my learned friend points to paragraphs 37 and 38 and says that the impact of calling it private rather than family life meant that too much weight was given to the fact that the relationship was formed when it was precarious. But if I could invite the tribunal to turn up Mobeen, which is behind tab 7 of the authorities manual, the tribunal, I'm so sorry, the court, turn up behind tab 7, page 136, paragraph 49. Which states that
Which paragraph, sorry?
paragraph 49, a central consideration when assessing proportionality of the removal of a non-settled immigrant from a contracting state in which they have family life is whether the family life was created at a time when the immigration status was precarious. So my submission is that regardless of how family life, private life is labeled, in this case, it simply wouldn't have made a difference.
Yeah, well, these references, Hagyako and Jones, are the ones my lady was referring to in saying we had this very point on Tuesday. Um, yeah.
And the other, while the authorities bundle is open, the other relevant authority is that which I refer to in my skeleton argument, which may well have been before the court earlier in the week, is Singh, on behind tab 11.
No, I didn't. We did have Singh.
Oh, okay. Well, this is
Maybe we did.
a 2015 Court of Appeal decision, and it was a
Which
similar,
tab did you say? Sorry.
Sorry,
Tab 11.
tab
Tab
11.
11. Yep. It
It was a similar case as to that here, insofar as the judge found that a private life was established. It's in paragraph 22. And then, essentially, the argument was, does it does it matter if you call it family or private life?
Mm-hmm.
And that's at 24 to 25.
Yep.
So if the labeling doesn't matter, then that means that the supplemental ground is not arguable. And that is essentially the point made by the judge, Mr. Justice Griffiths. And if we just turn back to that, starting with page 72, essentially the gist of that analysis. Paragraphs 27 through 32.
I'm sorry, page reference again.
It's page 72 of the core bundle.
Thank you.
And it's just taking one last quick trip through Mr. Griffith's analysis at 27 through 32. And at 27 and 28, we see the review of the proportionality analysis. And essentially the point is made that all the relevant factors were taken into account. And then as to my learner, in the specific point around the weight to be placed on family life was assessed in that same paragraph in Mobeen, which I've just taken the court to cite it. And then at 29, first the judge finds that the finding about the absence of family life was justified, that it was appropriately characterized as private life, giving the nature of the bond, the nature of the blood relationship, and the fact that this was primarily a relationship which was about someone caring for someone else, as opposed to a more rounded family life type of relationship. But even if that's wrong, the characterize this as a strong private life worthy of respect, based on all the same factors as would have come into play had there been a family life.
Yes, if it says had he found, it's had she found, isn't it?
Yes, as she found it, yes. She. And then the same analysis is really repeated at 30.
Except that it's a she in paragraph 30.
Yes, well.
We wouldn't be rude about the judge anyway for an extemporary judgment,
No,
but anyway,
no.
we're probably being rude about the transcriber.
Yes.
Yes.
Probably.
Well, to be fair, my instructing solicitor was quoted as appearing, and it was in fact me.
Oh.
So, for your note.
I'm sure that was the transcript. Oh, right.
Oh, right.
We didn't. I hadn't.
So I made an impact, clearly.
And the judge didn't spot it when he corrected the transcript.
So just out of curiosity, I want to see how things are done these days. The judge literally, as soon as counsel sat down, goes straight into judgment, not even take lunchtime.
No.
Done his homework beforehand.
Yes.
Yep.
Well, and those were submissions. I think I bound up my learned friends ground 2 in my respondents notice ground 2 in one go. But unless there are any further, unless I can be of further assistance, those were my submissions.
Yeah. Thank you very much, Mr. Hurley. Yes, Mr. Malik.
Lady and Lords, my learned friend at the outset made submissions as to the source of the test in section 11A, and made a submission that it's a high hurdle. That's uncontroversial, but that does not, in my respective submission, justify the gloss that Mr. Justice Saini placed on the wording of the statute in Oceana at paragraph 33. Milan Trent says that the judgment in Sapaio is different because that judgment deals with applications for permission to apply for judicial review, whereas the issue in this case is about permission to appeal. Now, you have already considered the rules as to permission to appeal. May I just draw your attention to Rule 28 of the Upper Tribunal Procedure Rules that concerns permission to apply for judicial review. You have that rule behind tab 3 of the authorities bundle, page 32. And you'll see that the wording is materially the same. If you look at Rule 28.4, it said the application must state, and as Lord the Vice President said, a person adopting a literal approach would say that, look at 4G, it says facts and grounds on which the applicant relies must be submitted with the application. So it's not different from the rule that concerns permission to appeal. Yet this court held that grounds can be amended without the tribunal's permission before service. So what is true for this rule, in my submission, is equally true for the other rule. But my learned friend made, in any event, an entirely fair concession that if the judge had considered the supplementary grounds, in all likelihood the judge would have granted the application to amend the grounds. And therefore, in my respective submission, the out of time point is not a knockout point against my case. Now, my learned friend then took you to Rule 43 of the procedure rules, and then to Rules 45 and 46.
Yes.
She makes a submission that there is a difference between power set aside and power of review. You have already seen Rules 45 and 46. Well, those rules concern permission to appeal to this court, not permission to appeal to the Upper Tribunal. I wasn't sure if that was Milady and Lords noticed that when looking at those rules.
I'm not sure I did. I can't speak for my...
Yes.
Can we just look at them again?
Yes. So page 40, Upper Tribunal's consideration of application of permission to appeal. This is not permission to appeal from the first year tribunal. This is permission to appeal to this court. Yes.
I think that yes, Part 7 is correcting, setting aside, reviewing and appealing decisions of the Upper Tribunal. I think it was for that reason I was finding it so difficult to see how it all fitted together.
This is permission to appeal to this court, where the Upper Tribunal has made a substantive decision.
So the Upper Tribunal can fall on its own sword?
Yes. Yes, if you put it in that way, yes. When the Upper Tribunal grants permission...
Yes, I see. No, I was across, but the same goes therefore for review too. I mean, it's not about reviewing the FTT's decision, it's about reviewing its own decision.
an excluded decision, of course. But those rules are not about permission to appeal from the first tier tribunal to the upper tribunal. These rules are about permission to appeal to this court, where the upper tribunal makes a decision dismissing or allowing the appeal. A party makes an application to the upper tribunal for permission to appeal to this court. Instead of granting permission to appeal, the upper tribunal may do that.
But all right, but that's all very well.
Yes.
But what about 43?
Yes. So Miller and Friend says that the power to set aside in 43 is not power to review. Now, there are, in my respective submission, two fundamental problems with that submission. Now, the first is of practicality. Now, if this court adopts that approach, then I do invite the court to consider the consequences. Well, that means that a person is able to apply to set aside the upper tribunal's decision on the grounds of procedural irregularity to the upper tribunal, and if the upper tribunal refuses that application, on appeal to this court. But that person cannot apply for judicial review to set aside the upper tribunal's decision on procedural irregularity ground, because the judicial review is limited to Section 11A grounds.
You mean it would be easier to get to this court than to get to the High Court?
Yes, but precisely. I mean, I'm happy with that in a general sense, and my colleagues at Immigration Bar would be excited about that prospect. But that, in my respective submission, makes the entire, at least compromises, the fundamental scheme of Section 11A, which was to restrict the ability of an applicant to challenge the upper tribunal's decision to specified grounds. If, for example, the upper tribunal has made a decision of this sort or made a decision without giving adequate reasons, I mean, why would a person apply for judicial review? That person, which is available only on Section 11A grounds, that person would ask the upper tribunal to set aside its decision, saying that, well, you haven't given proper reasons and that is procedural irregularity. And if that application is refused, appeal to this court. And this court, applying 43, may intervene if there is simple procedural irregularity. Well, that is good enough for many applicants, but it makes, in my respective submission, no sense as to the scheme of Section 11A.
Could it not happen this way, that an application is made under 43? Yes, I see. No, Dorothy, I see your point. If an application is made under 43 and refused,
yes,
you appeal against that.
In this court, on the first appeals test. I mean, what? And why would an applicant in those circumstances would even think of going to the High Court, seeking to surmount?
Well, all right. I mean, suppose you're right, but how do you prevent that being the position, given its literal language?
Okay. Now, yes. So practicality is the first point, and in my respective submission, a strong indicator that the proposition that is being put forward is not right. That would effectively mean that. Would lead to a situation where Section 11A loses its force. Now, how it works, the authority may assist on that. Now, the true analysis in my respective submission is that there is no material difference between the power to review and power to set aside. You only set aside a decision after reviewing it.
Hang on. Well, draftsman seems to have thought they were different.
In the rules, of course. But can I just show you an authority that may assist? And submission that is made is not entirely consistent with the authority. And that is the same judgment, Lady and Lords, that we were looking at earlier this morning, the judgment in Sathayo. So there was an issue about amendment, but there were other issues about the ambit of Rule 43 and 44 and 46. Now, can I take you to paragraph 42 of the judgment? Now, this is, you'll see a reference to the judgment of this court in Patel. Now, that was a case where the Upper Tribunal, at an oral hearing, granted permission to appeal and then proceeded to hear the full appeal. Now, I wasn't doing a good job. So rather than persuading the Upper Tribunal to allow the appeal, I ended up persuading the Upper Tribunal to hold that the grant of permission was the wrong decision. The Upper Tribunal took the view that permission should not have been granted. The Upper Tribunal essentially set aside the grant of permission. There was an appeal to this court on the basis that the Upper Tribunal had no power to set aside, to review the grant of permission. The appeal was allowed.
Sorry, you should have got the appeal dismissed, but instead you had the grant of permission revoked. Is that what was going on? Is that what you told us a moment ago?
Yeah. So permission was granted. Permission to appeal was granted by the Upper Tribunal.
Yes.
The Upper Tribunal then took the view that permission should not have been granted.
Yes.
And the Upper Tribunal therefore reversed that decision.
Right. So that instead of going ahead and getting the appeal dismissed,
yes,
you knocked out the original permission,
yes,
and that's what led to the appeal.
and refused permission again.
Yes.
There was an appeal to this court. This court said that once you've made a decision on permission, that's it. That's an excluded decision. You cannot review it. You cannot set aside it. Now, that judgment, Patel, was considered by the Upper Tribunal in John, which is paragraph 43. And see what is quoted there. What was said in Patel.
Should we just read the whole thing?
Yes. Paragraph 43, the quotation on the next page. Yes, the first paragraph of the quotation, paragraph 25.
I see. And accordingly, no power to set aside the grant of permission.
And accordingly, no power to set aside the grant of permission. So you review a decision to set aside it.
So set aside is the order which
Yes,
follows a successful review.
Yes.
I don't think that's how the draftsman looked at it in the 2008 rules. He seems to have thought they were separate. You're not sure. Do we need to read paragraph 27?
No. 26 is.
It's just that last sentence. Yes, I see.
So the submission that Appellant makes is wrong in principle. It has issues as to practicality. It undermines the statutory scheme, and it is inconsistent, in my respectful submission, with the authority. Plaskin is not an authority on this particular point. The issue in Plaskin was whether a Rule 43 decision by the Upper Tribunal attracts the right of appeal to this court. But in my appreciate that this discrete issue is not entirely straightforward.
No.
Now, the court only needs to decide this issue if the court takes the view that, well, our failure to apply under Rule 43 is a disqualification. It's a knockout point. And my submission is that it's not. If it's a knockout point, then no judicial review will ever reach the High Court. a case that meets the test in section 11.4a, namely there is procedural defect giving rise to a breach of natural justice, inevitably falls within Rule 43. Inevitably, a case
Well,
that
this is
meets,
you just making again, very clearly, but making again the point you made the other heading impractical. Well, this is a further point.
this is a further point,
Oh, I see, sorry.
which is this, that if it is a knockout point, then no case will ever reach the judicial review court, because a case that meets section 11a test by default would meet the test in Rule 43c, because the test in Rule 43c is mere procedural irregularity. So where there is a defect in the decision of a kind that robs, that gives rise to a breach of natural justice, it's difficult to see why that wouldn't be a procedural irregularity. And that would be an answer. That would be the answer to every single case based on section 11a 4 Roman 3 that would ever come to court. So it's not a disqualification. But irrespective of what view Canadian laws you ultimately take as to the law, when judicial review claim was filed, when the Upper Tribunal refused permission, the settled position in my respective submission was that inviting the Upper Tribunal to review or set aside refusal of permission wasn't an option. It's now debatable, but it wasn't then. And it's not, in my respectful submission, a disqualification.
Well, the statement says that if it's debatable now, it was debatable then. All that's changed is Pleston, and Pleston's just a case.
Yes.
The rules haven't changed.
Yes. Yes. You have my submission.
I see.
Just made the point. It was essentially a practical point to make it clear as to what was happening in our minds at the time.
No, I understand.
I mean that wasn't something that crossed our mind in the light of the case law that was in place then.
Yeah.
Well, you also, I mean, you're clinging to paragraph 28 of CART.
Yes.
I mean, that's, we started that
Yes.
a few hours ago, and it's taken quite a lot of unpicking to get to where we are now.
Yes. CART, of course, then this court's judgment in Padale, the Upper Tribunal's decision in John, this court's judgment in Sapaio, essentially making the same point. So it's not a disqualification, it's not a knockout point. So if the court is persuaded that section 11A test is met, then in my submission, permission should be granted, the appeal should be allowed. On merits, just very briefly, you have seen the presidential guidance note that I ended up.
Yes.
Can I just show you one further paragraph that may assist you in relation to a submission that Miller and Friend has made on merits, and that is paragraph 37.
37.
Yes, it comes immediately after the arguability paragraph. So where there is an error of law, there is an arguable error of law, permission should only be refused if the outcome is inevitable. The facts must be capable of bringing the case home.
Yeah.
Now this is the test that the Upper Tribunal would have applied or would apply. So the question is not whether the error alleged is material to the outcome. That is not the question. The question is whether the outcome is inevitable. This is an appeal that is bound to fail. It is incapable of succeeding, and in my submission, it is at least debatable. It's not bound to fail. Miller and Friend showed you a passage in Mubin. This is paragraph 49 of Mubin, which talks about exceptional circumstances.
Well, if we're talking about the same paragraph, the point of it was that although the actual phrase "little weight" isn't used, the
Yes.
essential point is that the considerations about precarity apply just as much to family life as to private life.
Yes, but
Perhaps you make another point, but that's what I thought 49 was being cited for.
yes, but this is not, in my respect, machine. What 49 actually says. It
Right.
does not. It does not say that little weight provision apply also to family life. It says that in precarious family life cases, the appeal will succeed only in exceptional circumstances.
Sounds quite like little weight to me, but
Now, now, giving an example. I mean, if a private life is established when a person's immigration status is precarious, no matter what justification that person has, the statute says attach little weight. But when it comes to family life, there's no sort of automatic attribution of little weight. The decision maker will look at whether there are any exceptional circumstances, background, context, and then make a decision. And this is not what, in my submission, at least arguably, this judge did. Miller and Friend took you to a passage in Singh and made a submission that, well, there is no difference between private life and family life, and labeling makes no difference. Well, I entirely accept that. My point isn't simply that the judge has used the wrong label. That isn't my point. My point is that it is at least arguable that if the judge had proceeded on the basis that the family life limb was engaged, then there is a prospect of a different outcome. That was a case where, of course, just to make the obvious point, permission to appeal was granted. There was an appeal at the Upper Tribunal. The Upper Tribunal at the appeal said that the error alleged was immaterial. But we are not at that stage. One final point, which is that when considering, I mean, if permission to appeal is granted to the Upper Tribunal in a case of this sort, the Upper Tribunal would apply the anxious scrutiny principle in considering the ground.
you made this point, yes. Yeah.
Yes. Well, I made the point in the context of the reasons given by the Upper Tribunal for refusing permission to appeal. But the point also applies to the reasons given by the first-year tribunal. Can it be said that the judge of the first-year tribunal considered every factor which might tell in favor of the appellant? Whether the judge has properly taken into account every factor which might tell in favor of the appellant, and whether the decision shows that is the anxious scrutiny requirement. And therefore, in my submission, there is a clear error of law in the first-year tribunal's decision. Whether or not it is material is a debatable question in my submission for the Upper Tribunal. I'm very, very grateful for the patience.
No, thank you very much.
These are my submissions. Lord, the Vice President made a reference to, when I was making my submissions in opening, to the provisions as to reopening of the appeals.
Yes.
Now that is Rule 5230.
Yes.
We have printed that.
I think it's engraved in the hearts of all three of them. We don't need the rule. Because it's a kind of application we get increasingly
From
often.
time to time.
Yes, and no. So what Mr. West has done is that he has not only printed the rule, he has also printed the white book extract relevant to
Well,
that. If you don't
that's-
need it.
We'll have that, thank you. But I was really only interested in the particular point about the example given of the judge who reads the wrong papers, which seemed quite close to this case.
There are, that example you won't find, I'm afraid, in the extract, but there are a number
Well,
of
it'd be churlish to say we don't want it, but I don't want to open up a whole new... That's okay, we'll have it.
Thank you.
Thank you. Anything else, Mr. Malik?
I'm very grateful, thank you.
With the indulgence of my lord and my lady, which I have to ask for afterwards. Dalen, the point that Mr. Malik made in his reply, which in fact he did also make first time round, and we didn't ask for an answer on, about the odd result that would be achieved if Rule 43 means what you say it means, i.e. if it's available in these circumstances, it will basically make 11A certainly the procedural irregularity limb of it, but perhaps all of it, a dead letter. That needs a bit of thinking about. Do you have an immediate answer to it?
Well, I think it's not quite as catastrophic as my learned friend makes it out to be. I mean, it is limited in the sense that there are the three quite specific examples, and then the procedural defect, but it's also in the interest of justice. I mean, there are two tests.
Well, I see that, but it might be thought to come to much the same thing.
But in the scheme of things, I'm sorry to if I give you more thinking time, then fine. But that in the scheme of things, the whole point of this was to really to reduce JR to a very narrow and residual category.
Yes.
And so I imagine your response is that if that's what is achieved by this scheme, then it's succeeded.
Well,
Yes.
that's perhaps not,
Rather than thinking about the effect,
not a pleasant outcome in this court.
rather than thinking about the
That's where
effect that it might have in this case.
that is one factor, but I think that, I mean, perhaps the more optimistic result is that it could resolve issues such as, I mean, it would have, if that route would have been followed in this case.
Well, it's obviously the sensible course if it's the one that the rules provide for and permit.
Yes, and if there is a procedural error, which
Yes.
can be, I mean, I think the floodgates are, in terms of cases that are characterized as procedural error, I mean, perhaps there's not, it would go either way, but there is certainly a set of cases that can be resolved by the use of that rules, and this case would be a prime example of that.
Okay. Well, I think that's... Mr. Mallet, you are entitled, I suppose, to rejoin, but perhaps you won't take it.
No, I'm good.
Thank you very much indeed. Well, we're most grateful to both counsel and those behind them for excellent and thought-provoking arguments. We're going to reserve our decision. Judgments will be circulated in draft in the usual way for the limited purposes identified in the Counsel General for Wales case. They can, of course, be circulated to the parties, but they can't be circulated to anyone else. Circulated to parties on the same embargo, but they can't be circulated to anyone else except for the purposes identified in the Counsel General for Wales case. And if they're circulated more widely, there's a risk of a contempt of court. Thank you very much.